Hey everyone, thanks for joining us for today's webinar. I'm Emily Marsh from the Greater Concord Chamber of Commerce. Really excited we can do another presentation with Orr Reno. They've been amazing partners with us throughout this pandemic and before then with the Legal Breakfast series, but have been hosting great presentations for us, and today's going to be another good one. Before I introduce our speakers here, I just want to do a little bit of housekeeping. We are going to record today's presentation and be able to share that video with you later. And also, because you're here live during the presentation now, you can submit questions. To do that, you're going to move your mouse or tap on your screen and click on the button that says Q&A. From there, you can just type in your question and no one will see those questions except for me and our panelists here, so it is anonymous. None of the other attendees will see what you are asking, so feel free to, submit questions as we go along. We'll have some time at the end specifically for that, but as things come to you, feel free to type them in. Again, you get to that by clicking on Q&A and then typing in the question. So I won't keep talking here, but I will turn it over to Meredith and Peter. Thank you so much, you two, for joining us today.
Good morning, everyone. Thank you so much for taking the time to be with us this morning and to learn a little bit about cohabitation agreements, prenups, and postnups, specifically as they apply to co-owned real estate between non-married individuals. So as Emily said, my name is Meredith. I am accompanied today by my colleague, Peter, who is here with us as well. So we will jump right on in, and please feel free if you have any questions throughout to let us know. We're happy to address them as we go. All right, so this is sort of that lawyer page that we're required to throw in here. This webinar is not intended to act as legal advice. It's intended just to be a learning experience together, and we're of course happy to address your questions. So how does this apply to you? Well, if you're in a romantic relationship yourself, if you're dating someone, engaged, married, or if you know someone in that situation, this may apply to you. It may also apply to you if you have a close friendship that you might consider making a rather large purchase with. So if you have ever considered purchasing real estate with someone else, this might apply to you. And even if you already own real estate with somebody else, this may apply to you. So if you've answered yes to these questions, it's great that you're here today, and we are happy to help you learn more about how you can protect your assets if you make the decision to purchase real estate with someone you are not married to. So we did just want to touch a bit on this trend that we are seeing in the United States and in other parts of the world as well. Cohabitation is really becoming the trend for couples. 70% of American couples are living together before they get married, and approximately 7% of Americans are currently living with an unmarried intimate partner. And over time, we really expect these numbers to increase. It's been an upward trend. So it's important for all of us to know, especially as people are getting married older and looking at buying real estate before they're married, how to protect ourselves in those situations.
I'll just add that my now wife and I actually bought a house and lived together before we were married. So we're practicing what we're preaching. And we also fall into that number. Chances are you probably know multitude of people who are living together, who own real estate together, who aren't married, maybe have no intention of becoming married. So this is, I think, a very relevant topic to a lot of people. And I think as the numbers show, as Meredith explained, it's going to become more relevant to us over time.
Absolutely. So just like Peter said, a great example is you and your significant other find that dream house, if you will. It's a great deal. It's in the right neighborhood. It's everything you want. You decide that you're going to both contribute funds from your individual accounts to purchase the home. You move forward, you buy it together, you move in, live together, everything's going great. But 2 years down the line, you break up. What happens to that house? That is what we are going to answer today. So what happens when the relationship breaks down? So you have a few options. However, as you'll see, The first two options involve agreeing with somebody that you are now in a bad relationship with in some way, whether it be a breakup or some sort of falling out between friends. And as you can imagine from your own personal experiences, this is not the best time to be making large financial decisions. So if you do find a situation where you could do that, that's great. You could agree to sell that property together, or agree that one of you will continue to reside in the property and the other will essentially buy out that interest. But the reality is that for most couples, partition action becomes the way to get out of that situation. And our partition action really means putting it in the hands of the court. So couples give up a lot of decision-making power with a partition action if they choose to not settle and leave it in the hands of the court. This means that the court could force the sale of the property or assign values with the couple to determine who resides in the property long-term. It's a very long process, and as you can see here on this slide, a very expensive process often. $15,000 to $50,000 in legal fees are costs that we have seen, and that in reality will likely just continue to grow over time. And the unfortunate part as well is this could go on for over a year. So not only is your money tied up in that piece of real estate for over a year, you're still dealing with that ex, so there be an ex-friend or boyfriend or girlfriend, that a year later you could still be, exchanging conversations with, whether it be settlement or in court, trying to resolve this matter. And for most of us, we just want to move on at that point.
So like Meredith said, the easiest way to get out of the situation is just to agree to sell the property, right? Usually if you can come to that kind of agreement, you can agree on a realtor, you put it on the market. And in today's market, you'll probably have 15 offers in 24 hours. You split the proceeds evenly and you go your separate ways. If one person wants to stay in the house, one person wants to leave, it can be relatively easy-ish or doable to agree on what kind of contribution the person leaving the house will get for his or her share in terms of the ownership of that real estate. If one person says no, no matter how unreasonable, no matter how irrational though, as Meredith mentioned, the only way to divide the interest in that real estate is through a partition action. It doesn't matter how absurd someone's position is. All someone has to do is just blockade the process. And the only way to get through the divide that real estate interest is through a superior court or a probate court action.
That's absolutely right. And like Peter said, we're all seeing right now, the real estate market right now is so hot. I mean, properties are flying off the market. So you might be thinking, oh, well, it's a great time to sell if you were in this situation. Let's just sell the property and be done with it. But the reality is, if you can't agree, you could be tied up in litigation for a year to a year and a half, if not longer. And at that point, who knows what the market might look like. So you can also find yourself missing out on an opportunity to get into a really good market to sell. So just like we've been saying, agreeing to agree down the road, it sounds like a really good idea when things are happy and rosy and just starting out. But the reality is that it's really difficult to do that when the relationship has turned sour, and typically leads to a much more complex, ugly situation that causes both parties to expend significant funds that they didn't anticipate spending. So how do we avoid this? Well, that is why we are here today, cohabitation agreements. So what are these agreements that we are here this morning to learn more about? Essentially, they're agreements between homeowners that define and memorialize the agreed upon terms of real estate ownership. This means that essentially we're protecting unmarried individuals as they enter into these agreements together. We're defining each party's financial contributions and securing the financial matters for both parties moving forward. But before we discuss these cohabitation agreements in detail as to what they can include, what they might look like, we need to understand how property can be owned in New Hampshire. So in New Hampshire, we have two types of ownership: tenants in common and joint tenants with rights of survivorship. These, although they might sound similar in some ways, they're very different, and it's important to understand which one is the default in New Hampshire so you can ensure that you pick the one that works best for your relationship. So tenants in common, this is the default in New Hampshire. It's ownership by two or more individuals. There are no rights of survivorship, and each party owns a percentage of the property. Now, by no rights of survivorship, what we mean is that if one party were to pass away, the other party would not be entitled to that party's share of the real estate. That party's share of the real estate would go to their beneficiaries. In some cases, if they didn't have a will, it could be their parents or children. It could extend down through their intestate survivors. This can get really messy, as you might imagine. So if this is something you'd like to avoid, you would be looking at joint tenants with rights of survivorship, which we'll discuss here in a minute. But the important thing to remember is that this is the default in New Hampshire, tenants in common. So if you do not want this ownership, you have to ensure that your deed specifically includes the rights of survivorship language that we'll discuss now. So that would put you in joint tenants with rights of survivorship ownership. What this means is that if one party were to pass away, the other party would be entitled to their share of the real estate and become the owner. This can be a great tool for couples that find that they want this, but it also for other couples is not the right option. So it's important to really consider which one of these is best for your relationship.
And just to add to that, the time to get this right is before you sign the deed, before you sign the closing paperwork. There are situations, we've had cases where people think they have a joint ownership, meaning like when they die, it'll pass to their long-term significant other, only to realize that upon the decedent's death, it's actually a tenancy in common. And now you have some interested descendants, kids, relatives who have a 50% interest in this share, who are now potentially litigating against decedent's significant other for an interest in the property that the decedent never wanted these people to have in the first place. So kind of the thematic to our presentation to addressing these things preemptively is you want to ask these questions now, you want to get the information now, you want to anticipate and preempt potential conflicts that could happen down the road.
Absolutely, and like Peter said, unfortunately, we do see that a lot. So it's something to think about early rather than down the road, or perhaps when you're unable to help make those decisions anymore. So jumping back into our cohabitation agreements, now that we understand the ownership options we have, what can these agreements include? And the reality is they can include a lot. And it's really important to consider all of these aspects here and make sure that if you want something included, it is included. So the first thing that most parties will include is their respective contributions. How much money did each party put up front? Was there any labor done by either party? So for example, if one party put up $10,000 for the down payment and the other party said, I'm going to refinish the basement off, adding more living space to the home, you'll want to memorialize that in your agreement. And you may even decide that you want to assign a value to that labor that was done in the beginning. You'll want to keep track of all of that as you go along. You'll also want to add an agreed upon process for selling. So if the relationship breaks down, how are you going to get rid of this property? Are you going to use a real estate agent? Are you going to try and sell it yourself? Are you going to give the other the right of first refusal to purchase the property? And how will you decide how much to sell the property for? Will you include an equation that works for you? Will you allow multiple real estate agents to be involved to help you decide what that value should be? These are all things that you should think about long before the breakup of the relationship, when it's much easier to make these decisions. The other things you want to think about are your responsibilities down the line. So what about unexpected maintenance costs, or if you decide to do renovations, who's going to cover those costs? Your monthly expenses, utility, home expenses, mortgages, who's going to be paying each month, and how is that going to relate to the ownership? Major assets. Are you purchasing furniture for the home, a fancy refrigerator? What happens when the relationship breaks down? Who's going to get that? And you'll want to think about, for example, like we've talked about, a real estate market like today, where there's so much appreciation on homes, who is getting it and at what percentage? So there's a lot of pieces here to think through in the beginning that are, as you can probably imagine, are going to be very difficult to handle when the relationship has broken down.
And it can be overwhelming to, like, just looking through these in a hypothetical situation. I would have a hard time answering these. The point, though, as Meredith has driven home, is that asking these questions now and having a dialogue with your significant other or your person you're buying a house with, asking these questions now, having a dialogue and answering them now, when the relationship is good, when you're full of hope, when you're full of amicable nature, is much easier to do this than when the thing has gone sour, when someone has cheated on someone or someone decides they want to break up and the other person doesn't, much more difficult to decide who gets the couch that you guys, bought in together 5 years down the line. So it is a lot of information. It's a lot of things to consider and decide. Infinitely easier to do so before the thing goes wrong than after.
Absolutely right. And Peter is correct. There's a lot here and a lot of detail. And you might find that for your relationship, you don't need all of these pieces. So there's certainly no reason to say that you have to have these included, but they are things that you want to think about, like Peter said, when the relationship is more happy than it will be towards the end of it. So just like we've been saying, the reality is that you can really put in whatever is going to work best for you and your partner, as long as it's not illegal, essentially. That could mean that there's something on that page that doesn't apply to you, or it could mean that there's something specific in your relationship that we haven't thought of. Anything like that is going to give both parties more security should definitely be included. And like we say here on the slide, there's no page limit, so feel free to get creative and add what you need to make both parties feel comfortable.
To the point that there's no page limits, it truly represents an incredible amount of flexibility tailored to whatever a couple or two people's individual needs are. I've seen cohabitation agreements that are a half a page. To your reader, we're each contributing $50,000. We agree that we each get $50,000 back if we sell the house, period. That's all that those people needed to memorialize. I've seen cohabitation agreements that are 15 pages long that tried to anticipate every potential possible contingency. Obviously, that's a little more work and a little more difficult to put together. But the point is that whatever your needs are, however straightforward and simple, or however complex, because of the nature of a cohabitation agreement and the flexibility it provides, you can basically come up and do anything you want within it that, again, isn't illegal or against public policy.
Absolutely. It's meant to work for you and your relationship. So what about down the line? Can you update this agreement? So I know for myself, thinking through some of these questions, I'm thinking, gosh, how can I even anticipate what renovations we might decide to do in the future? Maybe we'll add an addition. There's large things that we might decide down the road that at the time of buying the property, you just may not think of or even be able to contemplate. The reality is that you should continue to update that cohabitation agreement as these big changes happen. So if you do decide that you're going to add an addition, who's paying for it? How is that going to be worked out? Who's making the decisions? You'll want to add that all to your cohabitation agreement and execute it again. So it should definitely be a growing document with you.
And there's a section of people, a not insignificant section of people who are together, they're in an exclusive, intimate relationship together, but have no intention of ever getting legally married. So for those people where marriage is just never going to happen, a cohabitation agreement can actually serve as sort of a living document where every 5 years they go back. If they have kids, they go back. If their circumstances change, they go back, they modify it, they update it. So to Meredith's point, it can be updated and modified as often as the parties agree is necessary. There are no restrictions on how frequently you can do that.
That's right. So you might be thinking, I already purchased a home. How does this work for me now? Is it too late? Absolutely not too late. A cohabitation agreement can be put in place now if you've already purchased a home. It should include a lot of the same terms that we've discussed earlier for one purchased when the home is first being purchased, or one put in place when the home is first being purchased. But there might be some things that have come up over the years that you'll also be adding. You'll want to go back to the beginning though and recall who put in what your agreement is. And it might be helpful to look at your history, who has typically paid things, how have these decisions been worked out in the past, and if that works for you to carry it through into the cohabitation agreement. So now that you've decided you want a cohabitation agreement, how do you ensure that it's enforceable and it's going to work for you if the relationship does break down? So you'll want to think about giving each party ample time to negotiate and review. This includes giving both parties the opportunity to seek counsel of their choosing and to review everything and negotiate. The document should be fair. It should be a document that was clearly evaluated and thought through by both parties, that both parties agreed to freely without duress, those sorts of things as well. You'll also want to think about the formalities involved, having it notarized or a justice of the peace view your signature, And you'll want to hold on to this document, the original document, either in a safety deposit box like we suggest, or in some other place that you know it will be safe. We also would recommend having some sort of electronic version of it. That way, if for some reason it is lost or damaged, you at least have that to show that it was in existence as well.
So transparency is really the name of the game. At the end of the day, what the purpose of this document is to basically memorialize your agreements with the other person. So if the other side doesn't honor it on his or her own, you go to the court and the court says, looks like you entered into a cohabitation agreement. It's clear you had notice. It was a fair, substantively procedural agreement. So we're going to enforce it. So to the extent that the purpose is enforceability, being transparent, being open about your finances, your contributions. If the other party has questions about your contributions, providing that information, anything you can do to show the court that this was a fair agreement, arm's length transaction between consenting and informed adults, the more likely it is that the court would find it to be enforceable.
That's right. And this might sound like a lot of time to put in the beginning, especially if you're trying to buy a house in a heated market like this one, but it really doesn't have to be. It can be a simple process. The reality is that both parties need to feel comfortable and like they had the time they needed to fully interpret and understand the agreement. So what happens if you like your cohabitation agreement and now you've decided that you and your partner are going to get married? How do you continue that agreement into your marriage? Well, that is what a prenup is for. So a prenuptial agreement is an agreement between two parties that are contemplating marriage, planning to get married, that defines their rights and responsibilities within that marriage. So for some couples, they might find that just essentially moving the cohabitation agreement language to their prenup, with of course some more complexities involved, is the right move for them. That they really don't need anything new or different. They just want it the way that it is and to move into their marriage with them. Other couples might say, nope, it needs to be expanded now or reduced to better fit our status now as a married couple. It's really up to the couple. Like we've been talking about this morning, it's really flexible. It's about what you want to do. Of course, the prenuptial agreement can also be a larger prenuptial agreement that includes all of your assets and goes through how you'd like those to be handled throughout the marriage. So it's not to say that you have to have a separate cohabitation prenuptial agreement. This can absolutely be a part of the prenup that you would form addressing all of your assets.
And then just to follow up, in terms of referencing a cohabitation agreement and a prenuptial agreement or vice versa, I actually had a case where two parties who were, both professional parties, they bought a house together before they were married. They entered into a cohabitation agreement. He contributed more, the guy contributed more money, so they agreed he could get more of the net sale proceeds in the event of a breakup and a sale. They ultimately decided to get married. They did, we did a prenup for him. She had independent counsel as is required. And they actually wanted to incorporate the cohabitation agreement in the prenup. But between the two of them had negotiated that because of other contributions each had made, that they would update that agreement so that they'd each be entitled to 50% of the net sale proceeds. So that occurred over the course of probably 5 years. And it's a good example of how when they first bought the house, they had an agreement, and then that agreement sort of evolved and morphed over time, and they updated it through prenup to reflect their circumstances then existing. So again, infinite flexibility, total possibility in terms of what both parties want to agree to and can agree to.
Absolutely. And like Peter said in the beginning, back a few slides, you can update as much as you'd like to. So you could have updated 3 different times before getting married and then do it with a prenup. There's really no limit. So what if you're already married? Well, we have postnups. So these postnups are intended to do exactly the same thing really as a prenup, define the responsibilities and rights of the married individuals. And they can carry on the cohabitation ideas in a married situation. So you can explain the terms of ownership, the contributions of each party, the agreed upon process for selling, and any other terms that are going to work best for your relationship. You will see that we note here that some jurisdictions recognize a higher standard of review when determining whether prenups are enforceable. This is a very active area of the law that is growing, but at this time, postnups are definitely something that married individuals should consider as it relates to property, as well as other aspects of the marriage that they may want to include. So what is all of this going to cost? It's a case-by-case situation depending on the complexity of what's involved. Typically a cohabitation agreement, we would say, could be done for around $3,000. For postnups and prenups, it's about $4,000 to $6,000, again, depending on the complexity. However, as we talked about in the very beginning, talking about $15,000 to $50,000 in partition litigation, you can see that the numbers are drastically different when the relationship is simply addressed in the beginning, when everyone's in a much better mood. Taking these precautionary steps in the beginning can save you countless amounts of money in the end. Litigation is extremely unpredictable. Although these are the numbers we have seen, depending on the situation that you find yourself in litigation, that unpredictability can lead to even more costs. And as we note, divorce actions can be much more than these partition numbers that we are referencing here. So
Meredith and I actually lived through this not too long ago. We had a case together, a cohabitation gone wrong case, almost exactly these kind of circumstances, these facts. Parties, you know, had their exclusive relationship. They decided to buy their dream house in like the Manchester area together. We represented guy, girl contributed, you know, a fair amount more money. Guy contributed some money, but also, you know, part of his contribution was going to be sweat labor, sweat equity, as it were. He did some remodeling, was in charge of all the landscaping, some non-monetary contributions. Things went really well. They lived in a big, beautiful, you know, $500,000 home for a couple of years. And then things went wrong and they separated and they broke up. And because they hadn't talked about any of these issues prior, they couldn't agree to sell the property, or much less what to sell it for, how to value it. Neither party could really afford to live his or her own. And so what happened? She filed a partition action. Parties had huge disagreements about whether she should get full credit for all the money that she contributed, because I think there was a double dipping argument. She, you know, really just discounted a lot of his sort of sweat equity contributions. And at the end of the day, they each probably spent about $20,000 on attorney's fees. So instead of splitting, you know, approximately $120,000 net sale proceeds, they realistically only split about $80,000 net sale proceeds. So, you know, $3,000 on a piece of paper that defines and memorializes your agreement, it might seem like a lot of money. It certainly does to me, just looking at it, right? But if you think about it in the grand scheme of things, to spend if they had spent $3,000 or so on a cohabitation agreement when they were in love and they were going to spend the rest of their lives together, or so they thought, they, you know, would have realized a net benefit of about $37,000 to that. So these cases do happen. They are real. And again, spending a little bit of money to prevent potential big conflicts from happening in the first place, we're all about that. And I don't think the value of that can be overstated.
Absolutely. And like we said in the beginning, you have to remember, as you're spending all that money on that litigation, your initial investment in the home is still tied up in the real estate. You don't have access to that money until the property sells. So not only are you facing these high litigation costs, you have your investment tied up too, as long as it goes on.
How long was that case, Meryl? We were in it for like a year or so?
At least, yeah.
Yeah, so we didn't even have a trial in that case. We would have spent even more money if we did, and it would have gone on for probably another 6 months. So just to get information and negotiate and settle the case took them a year and about $40,000 combined attorney's fees. And I know, Meredith, you have another one going on right now that's actually might go to a jury trial, right?
I do, and it's a very similar situation. In that case, the boyfriend and girlfriend had purchased a property that they found that was a great deal for them. They had resided in it for a little while and then chose to use it as an investment property, started renting it out, and it was a great situation until it wasn't. And now, unfortunately, we're approaching 2 years of litigation that it does look like is going to go to a jury trial. That the costs involved are just crazy numbers, considering if they had just looked at a cohabitation agreement in the beginning, you know, for $3,000, it would have made a lot of sense in this case.
I think the real kicker in your case for me is that, correct me if I'm wrong, but neither party actually lives in New Hampshire anymore, right? They both moved away. They both moved on. Like neither one of them care about this property. They can't get out of this litigation, right?
That's correct, right? They both, you know, essentially they've tried to move on with their lives in every way that they can, but they're still joined together because of this real estate litigation that is continuing to go on. So what questions can we answer? That is all the information we have for you today. We've shared some of the cases we've experienced. There are many more. And we're happy to address any questions that we can.
And I think I'll add judgment-free, dumb questions. We're happy to answer what we can. So ask away. Our time is yours.
Yeah, we've got a bunch here in the Q&A. So if you guys, I don't know, Peter, if you want to pop that open, since Meredith has the PowerPoint.
I said no dumb questions, so I'm gonna live by what I say. Where do you find
So
that?
yeah, no, and this is for everyone else too. If you have a question and you don't know how to submit it, you should, if you move your mouse, see something that says Q&A pop up. Is that appearing for you? If not, I can read them off.
Oh, Q&A. Oh, yeah. All right.
Yeah.
Is
So
that
we've got a lot.
okay? So it's time stamped and everything. All right. So we'll go from oldest to most recent, if that's okay.
Yep.
All right. We're gonna answer live, right?
Yeah, sure. And just don't say names as we have indicated these are anonymous. Yeah, go right ahead. Great.
So this question is from anonymous. The question is, can people see the question? What is the average cost for completing this legal work? So we had a slide to that effect, and we, the lawyers that we are, we added that those are estimates, and it can be more expensive, it can be less expensive. The most efficient way is for parties to agree on everything from the outset, and then take it to a lawyer and say, their own lawyers, to be clear, and say, this is what we've agreed on. 1, is this illegal? 2, can it be done? And 3, do you have any advice for me? And chances are that if it's an arm's length transaction agreement, the lawyers will say, yeah, no problem. It's like, sounds good, not illegal. They can type it up, maybe add some special language to it to make it a little tighter. But the more that parties can agree on themselves, the less that lawyers have to negotiate on behalf of their clients, the cheaper it will be.
Completely agree.
All right. Second question, also from anonymous. Can a cohabitation agreement be made years after home purchase, even though the deed may be in one person's name? Yes. Yes, it can. Hopefully, optimally, if both parties had contributed to a home, the deed is in both parties' names. But a cohabitation agreement, that doesn't, even if it's in one party's name, that doesn't necessarily preclude you from entering into a cohabitation agreement, particularly if perhaps one person was more of a tenant, like one person owned the house, someone moved in, after a couple of years, their situation changed and both parties started to contribute to the home in some way, monetarily or otherwise, then yeah, cohabitation agreement is definitely something you can look at. Meredith, you want to take the next one?
I can't see the questions, unfortunately.
All right. I'll ask the question or I'll read it and then.
Sure.
All right. This one's actually by anonymous attendee. When you update the cohabitation agreement, does it need to be notarized or otherwise verified by courts? Good question.
Yes. So when you update, you'll want to have it notarized again. Essentially, you should treat it as a new document. You can attach it with your old one, but it's best to always have it notarized. That's the best way to ensure that it'll be enforced down the line.
And there's case law, the Supreme Court case on that found postnuptial agreements to be enforceable. My recollection is that postnuptial agreement was written on a napkin at a diner, and they found that agreement to be enforceable. So there is precedent that an informal agreement can be enforced. The best practices, the greater the formality with which you treat the agreement, the more likely it is that the court will determine this is an enforceable agreement. It was signed by parties that were, intelligent and knew of the terms and considered them and agreed to them. So when in doubt, definitely err on the side of formality, and having both parties meet and having their signatures notarized is a great way to go about accomplishing that. All right. This is another good question. Also by anonymous attendee. Do you have to sue someone to enforce the agreement in court, and how does that work? And the answer to that is yes, you do. The goal of a good, really any kind of agreement, any kind of contract, particularly with the cohabitation agreement, is it's so clear cut and it's so fair and it's so unambiguous that no reasonable party would want to spend the money to try to challenge it, right? And if that happens, then if they don't challenge it, then the only other option is that the only other realistic option is that the parties comply with its terms. If a party doesn't challenge it, but also decides to do nothing, then yes, you would have to go to court and actually initiate a lawsuit. That lawsuit, instead of being a general partition action, would effectively be a partition action with a motion to enforce attached cohabitation agreement. You'd hopefully have one hearing on it. The court would say, it looks like this is a perfect cohabitation agreement. I'm going to enforce it. You get an order, and then the terms of it would be enforced. So there's nothing that you can do to completely prevent having to go to court if the other side is going to be as unreasonable as possible. But having doing what you can to make the agreement as clear and unambiguous as possible in the beginning can be really effective in terms of limiting your court exposure. And oftentimes these agreements have an attorney's fees provision where if one party fails to comply with the agreement in bad faith or without just cause, the court actually has the authority to award the prevailing party his or her attorney's fees. So that's another way to kind of add sort of a deterrence of bad faith behavior. Anything to add, Mayor?
No, that's right. I was going to add the attorney's fee piece, so that can be added to your agreement to add some extra protection.
All right, so this is a really long question. I sold my house to move in with my significant other who owns a home. I pay rent each month that reflects our disparate earnings. She makes about 40% less annually, and we have evenly split utilities, TV, internet, heat, and about 10K in furniture costs, etc. Should I be doing something to protect myself in the event that something happens to my partner, health or otherwise? We are contemplating marriage in part to ensure I'd be cared for in the event of something unfortunate. No kids. All right, so that's kind of that's a loaded question that's pretty factually specific, and we're always kind of, this isn't the best forum to talk about specific factual situations, but my read on that is that if you have nothing in place, you don't have anything to protect you or ensure that whatever eventualities you and your significant other have discussed. So I would definitely consider doing something. I know that's not a very specific answer. I think that's the best one I can give in this circumstance. Okay, anonymous attendee, you said, the question is, you said postnuptial is uncertain. What is the current status of New Hampshire law on postnuptials? Any tips on making those enforceable under New Hampshire law? And that's a good question. To clarify, what's uncertain is whether the standard of enforceability for postnuptial agreements is greater than the standard of enforceability for prenuptial agreements. There's a pretty profound inherent difference in postnups and prenups. Prenups are entered into by persons who aren't married, who, if they can't agree on a prenup, have the freedom to just walk away and not get married. Postnuptial agreements are entered into by people who are already married. And courts have found throughout the country that in all, typically in that situation, you have one person who is more committed to staying in the marriage than the other, which inherently creates an uneven position of bargaining power. Like perhaps one, wife who is the earner is threatening to leave, and husband is desperate for her to stay because he is reliant on her income, and so she could, theoretically get him to agree to really unfavorable provisions in exchange for a promise not to leave, and that's something that courts have grappled with. So the uncertainty is whether there's a heightened sort of sense of scrutiny in terms of evaluating whether a postnup is enforceable or not. That's an open area of law in New Hampshire. The Wilbur case is the postnuptial agreement case in New Hampshire, the only one we have. And they identified that as an open issue, but declined to address it, as they often do. So how we advise our clients is best practices always in terms of transparency, openness, disclosure, fairness, basically erring on the side of caution, even if it, no matter what the issue is always the best way to ensure enforceability down the road.
That's right. And if you think you should have a postnup, it's absolutely something you should consider and look into doing, regardless of your concerns of it down the road. It's always better to have it in place if you think you need it.
All right, then it looks like our last question, also by anonymous attendee. I don't know if this is the same person or this is multiple people, but the question is, what is the case name of the enforced postnup in Supreme Court of New Hampshire? And that is, the case name is In Re Wilbur, W-I-L-B-U-R, I believe. I don't know the pin site. It's if you Google it, it'll come up. It's the only postnuptial agreement addressed by the Supreme Court at this time. And I remember when I was a law student, I was like super geeking out about this because it, you know, changed the landscape of what contracts could be entered into by married couples. Before then, people were doing postnups, but there was always a CYA letter. You know, there's no precedent that's going to be enforced. You know, like you should plan on this potentially not being enforced. And the Wilbur case really kind of gave certainty to the fact that we don't know exactly what the standard is in terms of whether, you know, if and when this is challenged, but we know that the court has ruled definitively that this is an enforceable agreement. So it was, you know, not to geek out a little bit, it was a groundbreaking case when it came out. The fact that it was written on a napkin made it even cooler. If you're, you know, in the mood for some light reading, though, I'd recommend checking it out. I
Those are
think
great. We only got one more submission, which was a thank you, some positive feedback there. I have a couple questions if you guys want to answer them. Yeah, going back to, you guys were describing the two types of tenants, one with rights of survivorship and one without, and mentioned that those are good to determine when you're first purchasing real estate and going through that initial paperwork. But can you change the tenant type partway through, and would you do that with a cohabitation agreement?
yes, you can, and yes, you could.
All right, that's pretty simple.
Yeah,
And
depending on what you agree to and what you want to do, you can absolutely do both of those things. They're changing the deed. There are exceptions to the real estate transfer tax, or you know, updating a deed that there can be costs and other complications. So you wouldn't want to do that willy-nilly. You want to make sure that it fits into the kind of overall framework and is consistent with the rest of your objectives. But to answer your question succinctly, yes, and you could.
all right. And then one more, you guys talked about home improvements, other large purchases that, you know, couples or partners of, you know, might purchase together. Is there, can you include like debt in these cohabitation agreements as well, to cover, you know, instead of assets, but the opposite of that?
Sure. Like we said, these are really intended to be flexible. So if you want to assign debts to individuals and address them in your agreement, you absolutely can.
So an example of that would be, you know, parties live together and they decide, you know, we're going to buy this house together, but we really want to have a big deck for barbecues and for, you know, patio or whatever. It's going to cost $20,000, right? You can decide and should decide, you know, potentially from the outset, to the extent that you finance it, if you split up before that debt is paid off, who's going to be responsible for it? Because I guarantee you, if you don't have an agreement on that before the thing goes wrong, each party's going to point at the other and say he or she should be responsible for it. So that's like that's a great example of like, yeah, like we're getting a deck. We agree that if we split up, you know, either we'll each be responsible for half of it, or that money will be paid off the top of the net sale proceeds prior to distribution. So that's a really good question.
All right, great. Well, we can continue to accept questions here, but if you guys are okay with it, if there's something else you want to add, I do have some chamber news to update people on if you're ready. Okay.
All right, I'll just say standing offer. If anyone has questions about cohabitation agreements or anything, you're welcome to call us anytime. Obviously, we're happy to talk to you for a formal consultation, but if you want to talk academically about it, I'm happy to do that as well. So feel free to call, and we're always happy to talk.
Absolutely, always happy to talk.
Great. You guys are a fantastic resource. All right, I'm going to stop your screen sharing, Meredith, and put my own slideshow up here. All right, just want to let you guys know about a few upcoming things here at the Chamber. This Thursday, we have our annual State of the State Forum with Governor Chris Sununu. This Thursday, 10 a.m. It's another Zoom webinar format type event similar to this. So when you attend, you're not on camera, but you can submit questions. It's a great opportunity to both hear from the governor, but also ask some questions really specific to Concord and hear about that. The following week, we have our legislative update forum with 3 great panelists. They're going to talk about legislation in this year's session, and I'm sure the state budget and some things to watch out for there. Then coming up the the following week after that, we've got a pretty full month of March events-wise. We have a webinar with programs to assist small businesses. If you're looking into applying for PPP round 2, or you already have and you would like to hear more about the forgiveness, there's a lot of programs offered right now, and this will give you kind of a rundown of what is available, how to access these resources, and it should be a really good session. So make sure you sign up for that, or if you are seeking resources related to COVID right now, we do have a special webpage that you can take a look at to access more information, and that is concordnhchamber.com/COVID-19. You can see the link on the screen there. And then this is a more, fun event. We've got our Citizen of the Year celebration coming up. It's going to be online, not Zoom. It's going to be so much cooler, taking place on a platform called Remo, where you literally see tables and chairs, and you can click to go sit next to your friends and automatically be in kind of a video chat room with them. It should be a lot of fun. And we are celebrating Linda Lorden as our 2020 Citizen of the Year. So definitely take a look at that. It's going to be a great celebration and opportunity for networking, a lot of fun. And finally, our Business Showcase trade show is coming up. This will be on the same format as that Citizen of the Year event. You'll see a trade show floor on your screen. You can click on a booth to go visit it and automatically be in a video chat room with the exhibitor to talk to them. This one's going to be a blast. We have exhibitor booth registration open right now. So if you would like to exhibit or learn more about this, you can learn about any of these events on our website, concordnhchamber.com. That's all that I have for you guys. Oh, no more questions are submitted. So I want to thank you both so much for this presentation. It was really interesting, really great information, and you both brought such great energy to this. I know it seems kind of intimidating to talk about these agreements, but you guys made it light and fun and made it make sense. So we really appreciate that, and all that Orr Reno has done for the Chamber through the pandemic and beyond, all these presentations that you share with us.
Our pleasure.
Our pleasure. Thank you.
Yeah, thank you to everyone who joined us today, and we will follow up with a recording of the session. All right, have a good morning, everyone.
Take care, guys.